Hi folks, I'll just be giving a very short introduction to all the illustrious speakers over here, myself not including. Uh, okay, so first we have Mr. Sachin Datta, Head Human Resources. Sorry. Oh yeah, sorry. I have the wrong side. That's what happens when you're given something to do last minute, right? Okay, so we have Mr. Sanjay Dutt, Senior Vice President and Head of Digital HR Operations, Statutory Compliance, Capability Development and Employee Relations, EXL Service. So would you please join us on stage? Next we have Mr. Vyapak Desai, Practice Leader and Head, International Dispute Resolution and Investigations Practice at Nishith Desai Associates. Thank you, Vyapak. Lastly, there's me. My name is Mauzam Khan. I also have a similar sort of a role than Vyapak. And I think with that, let's just straight away. He will be leaving us at 6:30. But more importantly, we're the only people standing between you and the drinks. So be economical with your questions, unless you really have something pressing, in which case, please feel free to interrupt us. All right. And another thing that I would just want to say before we deep dive into the topic at hand, this particular session is not limited just to POSH complaints and POSH investigations. We're going to try and cover, or rather focus a little more on investigations which are not POSH related. So we're going to be focusing on fraud, bribery, breach of confidentiality, breach of ethics, those sort of complaints, whistleblower complaints, and how you handle that, and not just investigations which are statutory in nature, right? So basically youin which you folks have a freer hand on deciding the approach, on deciding the team, on deciding the manner in which you'll actually conduct the investigation. So with that in mind, I think the first topic that we should have a little chat on is something which comes first to our minds when we're discussing internal investigations, which are whistleblower complaints. They're becoming increasingly popular. Their numbers are increasing annually. A fair number of times they can lead to some sort of a big risk for the company, for the corporation involved. Sanjay, I think to you, when it comes to whistleblower complaints, what are some of the best practices that you've encountered, or you would advise all the folks gathered here to sort of follow, so we can always try and learn from like they say, it's what smart people do, right? They learn from other people's mistakes. So what are the things that you would tell us?
Yeah, thanks. So just before I start, that table I don't think can get a proper view, so I hope you guys are okay, because I can't see anyone there. Oh, good, fine. I'll have to see the screen, but you aren't there, but fine. All right. So he missed out on asking me for my introduction, and I prepared for it because the last panel did. However, what I want to talk about is one of the early companies I started working for is American Express, and that was late 90s. And we thought that the world was nice and peaceful. And of course, 9/11 happened. But more importantly, for the financial world, Enron happened. And then WorldCom happened, of course. A lot of things happened. And I think the one thing which struck us was the fact that in those days, one of the early whistleblowers who kind of came into discussion was the whistleblower Sharon from Enron, and I think Ken Lay and Ken Schilling never paid any attention, and it just kind of went on. And in retrospect, a lot of people kind of look at that case and draw a lot of learnings. To my mind, before I answer your question directly, and actually to answer your question, Nazaman, is in our industry, the way the industry has grown, if you look at the IT/ITES sector, is that it's always been based and anchored on process excellence, right? So you have a lot of people, and it started with labor arbitrage. So a lot of folks, a lot of people, high volume, mass transaction processing, where quality of performance was typically determined by turnaround time, accuracy, and how, essentially if you've done things correctly or not quickly. And it almost became a stigma if you were not there, if you're not meeting the so-called metrics. And what Enron taught us, and quite frankly thereafter, that bad news must travel fast and it must get bubbled up. And actually bad news, early recognition of that is good news. So my first response to you, Ms. Amman, is that the organization, I know you talked about it earlier, has to have a culture of understanding that whistleblowing is not as much about the actions or the behavior of the person who's raising the issue, but it's really more to how the organization is reacting. So first point, the culture, and what's the initial reaction to the whistleblowing. Quickly, the other 3-4 points I want to talk about, it has to be dealt very quickly. There has to be very speedy dissemination of the incident and the issue raised to the right people. There should be definitely a whistleblowing hotline, or you call it helpline or whatever. You need to get your senior management involved. You have to have very clearly a body who's identified who's going to handle it. It can be, you can decide who or whatever. And finally, the couple of things is that the anonymity of the person has to be respected, and definitely no retribution. So these are some of the standards. We can talk more in detail, but I'm sure, maybe you have certain add-ons.
So I think just to sum it up, you say that first and foremost, you got to be fast.
Yes.
Right. So would you say, when you say fast, what's the time frame that we're talking about in general terms?
Because 24 to 48 hours with very speedy, accurate information. You also need to, so when I say act fast, it's not just dissemination, but also capture. So try and get written documentation of what's happened. And if not, just kind of record as much detail as you can.
So you're saying that engagement with the whistleblower for getting the written documentation and the proofs, etc.
Yes.
It's better. It's the sooner the better.
Yes. Yes.
Okay. And what about this this entire issue that whistleblowers face all the time, which is instead of receiving positive social sort of a recognition, there is an element of retribution, regardless of whether what we talk about. You see it happening often in big organizations where if it is perceived that a false complaint is made, or a complaint has been made against one of the your top money getters, top performers, there is an element of retribution. So how do we? What is the minimum standard of guaranteeing whistleblower protection? How do we do that?
Yeah, look, so there are quickly 3-4 points to it. First, like I said, it's really more about how the organization responds to the whistleblowing incident than the whistleblower themselves. So first, I think that there has to be adequate training and awareness. I do believe, we talk a lot about when issues come up, how do you handle it? But overwhelming majority of the issues happen because people are in the first place not encouraged to raise that, and you need to very, very strongly propagate. So I remember about 15-20 years back, there were a couple of organizations such as American Express, GE, etc., who started and those days you're talking about controls and the whole COSO framework. So really encourage and appreciate people who are bringing out transactions and difficulties. So I think there has to be very visible culture across the company which not just kind of encourages but actually rewards people who are bringing things up, one. And two, what really works, I know this kind of sounds a little off topic, but if you can prove to the people that the past whistleblowers in your organization have not made terrible, dark, dire deeds, but they've really kind of grown, and you show proof that they've done well, that's really going to be a big, big shot in the arm for anyone who wants to kind of raise. So remove the social stigma, show people that you're fine, and look,
old phenomena. It's something that you're seeing happening more and more recently. But where do you think all this has started? Why do you think lawyer-driven investigations are on the rise. What elements do external counsel bring in additionally to the table?
Sure. So I think one is possibly the concern raised in the earlier panel that sometimes internal HR may not be able to bring about the seriousness or the strength in investigation, and when an external lawyer comes in with the kind of expertise or with the kind of experience, that itself brings in a very different perspective when the investigations are going on. So there is a huge softer element involved in it. That doesn't mean that every investigation requires lawyers and we get the job. But definitely in situations which are serious enough based on the determination of the internal team, I think lawyers should be brought in at the right stage to make sure that you get maximum efficiency as you go forward. But one another important element to bring in lawyers is also an element of privilege. Because again, there are quite a few aspects to privilege here. Because otherwise, what happens is you conduct an excellent investigation internally. You say there was a vendor fraud, there was a kickback, there was a bribery, there was siphoning, there was a ethical issue, and all of that. And you actually create a, you give regulator things on a platter when things go outside in terms of any disclosure or otherwise. Plus, you do not know how you want to make those information available to more people than what are involved, or at least create teams or create Chinese walls inside the teams, and so on and so forth. So there is a huge element of advantage so far as that aspect is concerned. Now, coming to privilege and information that you may not want to go out, even in case when there is a litigation based on that going forward, or if and there is a regulatory inquiry based on that. There are two kinds of privilege that we are now talking about. One is privilege vis-a-vis the corporate itself, which is investigating. And second is the privilege vis-a-vis the inquiries or interviews that you would do with the people as part of the inquiry. Definitely, there is a clear indication and a clear path there that there would be no privilege that an employee can claim as part of the investigation, and that upjohn warnings or whatever the process has to be followed at the time of inquiry or investigation needs to be done. But more importantly, for the employer or the corporate itself, if there is an external lawyer involved, and if there are litigation or some kind of an legal proceeding in contemplation, or a dominant purpose established based on the investigation, there is a strong likelihood of claiming that privilege, and the report or the investigation or the material that the lawyers would prepare can be protected as part of the privilege. Now, the law in India is not very clear on this, because only source of privilege in India is your Evidence Act. And Evidence Act only contemplates litigation and an advocate, and in situations where a corporate or the person can claim privilege against the lawyer from not going into the system. So that it's a very different concept of protection, where a lawyer is precluded unless the privilege is waived, versus now a corporate is claiming a privilege just because a lawyer is involved. So I think it's a completely a different aspect, and there is some amount of law evolved in other jurisdictions, but it's pretty nascent so far as India is concerned. So documentation around that investigation, including the engagement of the external counsel, becomes that much more important.
Yeah, it also adds to the basic comfort of the investigating team and the corporate if there's external legal entity involved.
Why do you say that?
I just think that many times, exactly the point he's making, things are not very black and white, right? And I've seen several cases of inaction or lack of decision or pushing out decisions where decision was warranted and a quick decision, right? I mean, we heard someone saying, what if there's a threat of suicide and all? But if you have external legal assistance, people who are specializing in that area, you feel far more comfortable and you feel far more confident to go ahead and take the decision. So, by the way, I know there was this question which was raised, but my answer to that, I know it may just sound too 100 out of 100, call the bluff. If someone's threatening any action, just call the bluff, go ahead, get police protection, get legal protection, and just call the bluff. So that's where I get specialized legal assistance really helps.
And what do you say to Vyapak's point on privilege? How important is it for you? Is privilege actually is for you practically?
Look, you see, the underlying facts of investigation, if it goes on litigation, is in any case has to be presented, right? So the privilege gets challenged there. But I think that, especially with respect to a lot of things we talked about, for instance, POSH cases or even some of the InfoSec cases, etc., it's really crucial for us to have things under privilege, and that's why it becomes all the more important for us to A, do the investigation properly, have the investigators properly trained, know what they're looking for, restrict it to groups, and get legal assistance.
So we don't, frankly speaking, we don't have too much of guidance on what would be privilege and what not to be. Maybe if I take assistance of David here, he's a Queen's Counsel practicing in UK. I don't know whether this would be also privileged what he says here, but there is a very recent judgment in an SFIU investigation in UK, and maybe if you can throw a light and whether India can learn from a UK perspective.
Whether India can learn from...
Maybe you want to come up?
Thank you. Whether India can learn from the UK, I never know. I always worry about that, but we've learned more in terms of vocabulary from India than you have ever learned from us. This is a cautionary tale, I think, to an audience of human resources executives. ENRC and the Serious Fraud Office is probably worth outlining the facts so that you understand the problems that can arise. ENRC had a whistleblower in 2010, constituted an internal committee, brought in outside lawyers in 2011. The whistleblowing was that ENRC was paying bribes, engaging in corruption, those sorts of actions. And I think an important distinction, just looking at the sort of investigations you're talking about, is some investigations will lead to the decision, do you dismiss the employee or not, but probably won't have liability for the company. ENRC was facing issues where there was liability for ENRC as well. Late 2011, the Serious Fraud Office in the UK wrote to ENRC and said, we're hearing rumours that you've been dealing with fraud and corruption and bribery and whatever, and we're opening an investigation into you. Conversations went backwards and forwards between the SFO and the ENRC for about 2 years. At the end of the day, the Serious Fraud Office opened proceedings against ENRC and sought documents in those proceedings. The documents fell into broadly 3 classes, but the 2 which would be interesting in this would be interviews with ENRC employees by the outside lawyers, the actual notes of interviews in the investigation, and secondly, notes made by the lawyers in the course of their work. And at first instance, Mrs. Justice Andrews scared everyone in the investigations industry in the UK to death, because she said that those documents didn't attract privilege. And coming back to Vyapak's observation that in the UK, there are a number of heads of privilege, but the 2 big ones are legal advice privilege and litigation privilege. First of all, in relation to legal advice privilege, there is earlier authority in the Three Rivers litigation, which came out of the collapse of BCCI, which I'm old enough to remember. Vyapak isn't. But in that litigation, the client for legal advice privilege was defined as the company. and was defined as those people who were entitled to seek and receive legal advice. So talking to an employee didn't automatically attract legal advice privilege because that person wasn't the client. And in relation to the interviews with the employees, Mrs. Justice Andrews said, no, you can't attract litigation privilege because litigation for the 2 years until the SFO said, no, we're going to prosecute you now, wasn't in contemplation. The Court of Appeal in 2018 turned around and said, no, actually, on the legal advice privilege element, it was correct. The definition, the very narrow definition in England of the client is decided by the House of Lords and presently isn't being overturned. So it's a very narrow definition of who the client is. In relation to litigation privilege, however, the Court of Appeal said, no, proceedings were in contemplation. At the point when they had the whistleblower, in fact, ENRC knew that they were potentially in trouble. Did they have something that they had to report to the SFO? Because if they didn't, they could be prosecuted. Would they reach a settlement with the Serious Fraud Office? Would they be prosecuted by the Serious Fraud Office? And they had to investigate to define their position. So they said that attracted litigation privilege. But it also comes back to what Vyapak mentioned as to the dominant purpose of the creation of the documents. ENRC had created these interview notes, and the lawyer's advice was privileged so long as it showed the direction that the advice was going to ENRC. But the dominant purpose was important, that these were created for the purpose of the SFO proceedings. The issue that I think that arises here is, one, defining what your purpose is. If you bring in outside lawyers like Nishith Desai or the likes, you can say, we are worried that we will have an issue with our regulator and we have to investigate this to work out, do we have to settle, do we have to do whatever. The corollary danger for an investigation for corporate, whether with a whistleblower or whatever, is you suddenly generate, if you do it slowly, you generate lots of memos between HR and the C-suite and other people, and somebody saying, oh, what on earth has been going on? I don't know what's been going on. To the extent you generate that, that may not be privileged, and you may, as you said, have to hand that over to your regulators or criminal authorities.
Or the legal team, really. You just kind of route everything to legal and let them, kind of put it under privilege and confidential. Yeah.
So let me just firstly, David, thank you for your impromptu walk up to the stage. We're grateful. But let me just ask you a question while we have you here. What would have been the case, had the facts been slightly different? If, let's say, ENRC, they ultimately won on appeal, like you said, but if ENRC would not have gone down the external counsel route, let's say they would have, taken the help of their internal legal counsel. How would it have been any different? Should the companies do that instead?
In England, in-house counsel, their work and their advice can attract privilege. We don't have a terribly restricted purpose, but the mere fact that someone is legally qualified doesn't attract privilege. So in fact, one of the documents in ENRC was a memo to somebody who had been in-house counsel, was legally qualified, had in fact simply moved elsewhere in the C-suite. And that didn't attract legal professional privilege. So you can use internal counsel in theory, but of course it may be slightly more difficult saying, because it's the primary purpose. So if the primary purpose is preparing for litigation, you're okay. If in fact it's you've got one or two in-house counsel who do everything, and it looks like it's, rather than preparing for litigation, it's simply saying,
like a fact-finding exercise.
This looks ugly, what do we need to do about this? That, at that point, might not yet attract privilege.
And in India, this would be even pretty lower threshold because in-house counsel in that sense is not at all protected through privilege.
Because you're saying
they
they
are
don't
not
fall under the
advocates.
Advocates Act.
They don't fall under the definition of advocates. So maybe that is something that one needs to take care of, at least in situations which are likely to go further down the road and are important to.
But I think
take care
you still need to pay a little bit of attention when and if at all to
Not
bring
everything
in
requires,
external
but
counsel. Sanjay,
yeah.
you have a point to make on this?
I'm going to tell you, talk about a little bit of a workaround. So first of all, get really smart lawyers in-house. And that's really important, because many times you have legal, and I'm not casting any aspersions, but who just don't understand this. So get people who understand and partner with firms such as yours. And I'm not necessarily saying this to promote you, but it's really important.
Thank you anyways. But.
Yeah. Proactively, because I keep on saying this. We talked about this whole digitization, etc. It's really about proactively managing and try and addressing and preventing, rather than just kind of chasing your tails when it happens. So yes, I think we should have lawyers who are smart in-house. Yes, I think we should engage with external legal firms proactively.
I think that's a very, very practical advice, because regardless of whether or not privilege attaches to your in-house lawyer, he would definitely know the answer to the question
Or
on
she.
whether or not.
Sorry,
She. My apologies. He or she would definitely know the answer to the question on whether or not to engage an external counsel in this particular case, and that should be your guiding force. Sorry.
And I think if you think that through further, if you have established protocols, they will help you out. Because if you have a whistleblower, so if you have a whistleblower protocol, the whistleblowing won't be privileged. So if you have a whistleblower and you say, we will elevate it to this, it will be assessed by in-house counsel, we will, as part of that, we will assess in engaging external counsel, and then you speak. And so by the time you're generating interviews and the like, you've thought about things, that will protect you. If the danger is, if you don't have protocols, you have a whistleblower, and suddenly somebody at middle management level runs around and starts interviewing people, that gets very difficult. Protocols will be your friend.
Folks, I just have a little bit of a good news. Sanjay's meeting has thankfully been cancelled. He'll be with us longer. So now please fire all your questions
Now
whenever
it
you
depends
want.
upon how long you want to wait.
Yeah.
But please feel free to ask questions, comments, or your experience, because I think idea of bringing this forum is also, to have a knowledge sharing platform rather than, just giving out something which we will have very limited experience versus you all dealing on a day-to-day basis.
No, absolutely. I think now that we're done with this entire complicated issue around privilege, let's just jump straight into actually conducting, investigations. So let's say there is an issue, Sanjay, this is for you now. There is an issue which has come up. How does your team internally deal with it? Are they specially trained or given some sort of a crisis management training to deal with issues of a certain sensitivity? Do they know, or rather, have they been informed about, various issues, including, let's say, privilege, for example, including, how dawn raids are conducted, how data is preserved, so on and so forth.
Yeah, no, absolutely. Look, I think it's a combination of three aspects. The first is that there has to be a very strong process, right? The second is that there has to be complete awareness and education around that process, which is sustained and ongoing. And the third is, and I speak for many organizations, I believe, out here, most of us are, kind of headquartered in different countries, and we just kind of have large offshore locations, or you are multi-geography. Even within India, if you talk about the Indian context, you've got different geographies, different states, which are governed many times by different kind of issues. So I guess we need to ensure that while you're looking at, for instance, was one kind of topic I'm picking up. And it's not just about ensuring FCPA or BA, but it's also about just overall anti-corruption. So what I'm saying is just ensure that the local laws, local needs are addressed as much as, let's say, your kind of principal organization or geo. So just quickly going through some of the processes, I think people need to first of all know, let's take an example of crisis management. So all the names, all the people, all the specifics, you need to train people, you need to know the entire process, how do you kind of people respond to it. Most importantly, bound them with processes, these entire different issues, and ensure those processes are known. So let's take an example of data protection. Many of us, definitely in my organization, the client contracts necessitate us to manage our information assets and our, let's say, computers, laptops, or any of the mobile devices in a specific way to be given to certain people. They have to be, kind of bound by certain actions. You cannot do certain things on it, and they will leave an imprint which is complete, even if you delete some stuff and, kind of change stuff. So ensure that all those processes are there. After having, saying all of this, if you ask me what keeps me awake, or if I were to ask our CIO what keeps him awake, or our CTO, is still that after all of this, there are chances of slippage, which is why I keep saying that the whole employee awareness, motivation, kind of attention to this, ongoing education and communication is really crucial.
Just additional point on this whole issue of fraud or bribery and FCPA related points, right? I think earlier the issue was always that, look, from an Indian context, right, the real risk of getting a prosecution in that context was very limited because of the way Indian law was structured and the way the regulators were behaving. People were only worried if at all there is an UK bribery angle or a FCPA angle. But I think one big element which has changed in last couple of years is our own Prevention of Corruption Act. Now, the common understanding that it was only the bribe giver traditionally who is prosecuted and not the, or rather the bribe receiver is prosecuted and not the bribe giver, has completely changed with the new law. Now, the new law under the Prevention of Corruption Act puts bribe giver equally responsible and as an accused, and not, and this is like some administration guy, some sales guy, somewhere somebody sitting and trying to deal with the regulators or trying to get the sales out and meet their targets. They do certain things and you don't realize what is happening, and who gets prosecuted is the company and their managing director or the whole board, because now even under the Prevention of Corruption Act, the board is responsible for those acts. So I think when it comes to how to handle, right, the seriousness around some of these whistleblowers or even information which flows around the actions taken by the people in the day-to-day activities in dealing with regulators or dealing with customers or dealing with vendors and so on and so forth becomes even that more critical, and therefore processes like legal holds for at least the senior management needs to be implemented much more rigorously.
Elaborate a bit on legal hold.
So I think we all understand, right? There would be emails exchanges, there would be a lot of correspondence floating around in the system. The typical understanding is everything is saved on the server, everything is there somewhere lying in the system, and you can retrieve everything back. That may not be the case in many instances because there is an automatic wipeout over a period of time. How much all of that is preserved, whether, yes, as a general rule, nothing is deleted in that sense, even if you delete everything else, but still there is always a risk of something going out of the hold, and therefore institutionalizing legal hold, where people do not delete uh, on their own, and there is a legal hold also applicable to the servers on the back end, at least for the important people, or you may want to categorize who are those people who deal with that kind of people at a regulatory level or important customers or otherwise. That needs to straight away go to at least people who in first 24 or 48 hours who are identified as people who would be ultimately questioned or queried or interviewed. That lot of people would be an additional set of people uh, for whom you may want to issue a legal hold notice immediately in the first couple of days, rather than later when things go slowly out of a small group of people, because your ability to convince the regulator even going forward as to how robust your processes were will also determine how much it is attributed to the employee who was involved maybe in the course of employment, or the employer itself for not following certain processes at the back end, and therefore the penalties and the how much of that would be applicable on the board or on the employer or otherwise would also determine on that basis. So what you do would also become your defense as you go forward, and therefore that becomes even more critical.
So, just one point, and that's why, since you asked me what are the different things we should do from a, I think these self audits become very important. So, we need to really drive self audits on as regular a basis as we can to ensure all of this is happening, enough proof and evidence there.
So I think this is really interesting because what I see is a confluence of best practices coming from various jurisdictions, right? David, you spoke about what our learnings should be from ENRC, even though we don't have that particular law in place. Vyapak, you spoke about terms like legal hold and terms like upjohn warning that we're now learning from US, which is kind of leading the space in internal investigation. So this is obviously really helpful, and obviously it's something directly relevant to the industry. I'm sure a lot of you are already doing or rather using legal holds, at least for your senior management or in sensitive cases. I'm sure you already have that on client-related projects, that there are no delete permissions given to those individuals. But it's really helpful. Now, if I can just now come to straight, short, pointed questions, and where I get these questions are that actually the most frequently asked questions to us from our clients. A lot of them in your industry. And they're going to be straight, short, and pointed. Considering we're already on borrowed time now, and we don't want to shorten the drink session. Okay. First question. Vyapak, to you. If you're asked by a prospective client about recording the entire investigation process, like audio, video recording of interviews, what do you say? How do you respond? Do you say yes, we can do it? No, we can't do it. Is it preferable? Is it not preferable? Advisable? Not advisable?
So while it's a rapid fire question, I think answer
that's just the way I'm framing it.
At least the answer is little elaborate, because I think one is the strategic level, whether you want to record it or you don't want to record it. Because if you record it, obviously it can be used if at all you want to use it in future. But you may not want to record it because you don't want too much of that getting recorded, rather than only the conclusions, so that tomorrow at least there is not much of a record what went into the process, because most of this is not statutory driven. These are still internal at that stage. So I think the answer to that strategic is obviously the routine answer that we give to every client, that it depends, right? And then we stop there. But from a legal perspective, right, I think today there is much more flexibility in terms of those recordings. Uh, but as we go forward, in my view, those flexibilities are going to simply just go away. Because today we don't have a very stringent data protection law, we don't have privacy laws, which overflows in that direction. Though the way the winds are blowing, I think privacy and data protection is only getting stronger and stronger. And a lot of this will come under the protection, particularly the way the existing data protection laws and the white paper floating around, the government asking questions about it, the wider definition of private data as we see developing around the world, GDPR, and of course flowing to India as well. So all those flexibilities are going to go away. So I think typically consents would become that much more important, and it goes back to the processes, it goes back to the policies as to how you can put consents as part of your employee documentation, your internal policies, your internal processes. Can you put it preloaded in that sense when you sign the agreement, versus you have to take those consents at the time when you actually start the investigation? Because what will be more important is if this is the data you are processing at the time of investigation, whether that consent or an informed consent is taken then for any dissemination going forward, or they can actually claim that I will not share that data and you cannot take it any forward from there. Not only in terms of your investigation, but you can't even claim non-cooperation from the employee because it's his right or it is her right, rather than you saying that they are not cooperating. So I think as we go along, the complications will even become more critical in terms of those recordings. Today, coming to your rapid fire question and a rapid fire answer.
5 marks have already been deducted for giving too long an answer.
But today, there is absolutely no problem in doing it. But as a practical answer, usually we take consents before doing anything of that sort. And sometimes employees ask for recordings, and then you can't deny. But if you are doing, you can obviously ask their consent. But it's very important to tell the employee during the inquiry that the information is not protected by privilege. So you can obviously use that information without their consent. From a legal perspective, from data protection and privacy, it's a completely different angle.
Sanjay, following, sorry.
Yeah, please,
Absolutely,
please go ahead. Please feel free, because we can continue till the time we want to, and then we'll obviously cover as many other. Yeah.
Give an 8-minute answer to a rapid fire question. Thanks to a lawyer.
When it's on time spent, and so it's always elaborate. But today at least it's free. So
my question emanates from your discussion around recording of investigations and inquiries. So we had a very interesting incident about 18 months back where we did not record, as you know, we think that it doesn't really merit a recording. And the employee went ahead and filed a complaint to the police alleging criminal intimidation and illegal confinement. And the cops being cops, irrespective of whether they even have jurisdiction over such issues or employment matters, they land up at our office to check where actually the investigation happened. They checked the room and they said, oh, it's a glass room, so you really can't confine the employee. And it was really funny, but we actually started recording some of our difficult employee or sensitive employee situations, which we feel may actually snowball into an issue. So what are your thoughts around that?
So as I said, unless you think it's going to snowball, unless you think it's something that which is critical for you to even internally record and keep it for yourself, right? Typically, we don't necessarily advise people to record at the first instance, so it's not a rule. In my view, it should be used as an exception because there are more complications of recording than non-recording. What you obviously would record is notes around it and the conclusions around it, and that's good enough for the purposes that the investigation is going on. So don't do it unless there is an informed decision made as to, in this case, you may want to do it. But then again, situations can differ as we go along.
Yeah, I think
On GDPR, maybe David, you.
Yeah, I mean, on GDPR, which obviously may affect you if you've got subsidiaries or the likes affected by GDPR, 2 points. The kicker on consent is under GDPR, you can withdraw, the data subject can withdraw consent at any time. So one of the problems on consent is getting people to give advance consent in their employment contract, for example. If they turn around and say, I withdraw my consent, that's it. So what you have to do is you have to hold the personal data, and personal data under GDPR is very widely defined. You have to have justification for having the data and then holding the data. So taking the recording in the first place, you may be able to justify. If nothing happened after 6 months or so, then even if you dismiss the employee, then maintaining it and keeping that for 6 months or a year or whatever, there would come a point when it would be very hard to justify retaining that data.
so. I have a slightly different solution to your problem.
There's some question.
Yeah, let me just answer her question first, then I'll just come to you, sir. Slightly different solution. One which doesn't involve recording. Move it outside office. Have an investigation or an inquiry in a let's say a hotel conference room, in your lawyer's office, anywhere other than your office. This includes an inquiry which may ultimately require recording as well. Which an inquiry which requires recording will not only capture all the good things that you will be able to get from the employee, it will capture all your mistakes as well, right? So we need to be really careful in not just audio video recording interviews, but also transcribing them, word by word transcribing them, right? Because it's the same thing, right?
Sure. I think you had some.
Thank you. My name is Nishith. I represent DXL over here. So one part of it is the employer recording it, and of course you're saying that it may not become a part of the proof that you're submitting. Let me put it the other way around, that I'm not recording it as an employer, but my employee is recording. He might not, and there is no consent over it. I may not even know if the person is recording it. It might be just concealed. And in that case, when I go to the court, would that recording be a substantial evidence in the court of law, considering the employee did not give me the consent to record? So I just wanted to take a view of the legal team here on this point.
You have some answer.
Yeah, so let me just jump on that grenade. It is exactly that. It is a grenade. Okay, so firstly, you need to be really, really careful. You need to tell the person that you are interviewing that you're not recording, you're not supposed to record. We try and say that please switch off your cell phones during the duration of this interview. I think that's one way to do this, but obviously, you're not going to body search the employee that he's wearing a wire and recording something, So that risk can never be 100% eliminated, never. If there is something in that recording which supports his case and demolishes yours completely, then at least in certain family disputes, divorce cases, the courts have held that regardless of the fact that the recording was obtained without your prior consent, But if it contains something which is completely demolishing your case, I am entitled to look at it. The reason why Indian courts have done that is we're probably not as developed a jurisdiction when it comes to these issues on privacy, on consent. We're still catching up to our Western counterparts. We still don't have an ENRC decision. We still don't have a lot of laws in place which the US has on illegally videotaping or audio recording other people, right? So we still haven't caught up. There is still nothing preventing the court from looking into that recording. So please be very, very careful while doing that.
No, go ahead.
Yeah, Kalindi.
You're right.
Criminal breach of trust, the consent is not relevant at all. So, I mean.
No, you're absolutely right. So,
There was somebody else.
Oh, yes. Yeah. Okay, my name is Siddharth, and my case is similar to Nusrat, but with the difference is we faced a situation where the employee was insisting that I want the recording to be done. So he was insisting that, I want it to be video recorded on my cell phone. It's another matter that after a discussion with him, we were able to, persuade him not to record. But again, as Nusrat said, what is from the legal point of view? Is it his right to record these kind of things, or we can simply say sorry?
See, these are all internal investigations, right? So they don't stem out of any law. We don't have even a frame law on whistleblowing act, which is still pending for last many years, except few things in the listed entity space. But at least for internal investigation for unlisted, there is not much of guidance even on that case. As I said, data privacy is still not developed to cover those aspects. So there is nothing which prohibits or stops either ways, but this is something that you can put it as part of policies or processes and try to convince people. And that is why some of this becomes even more complex and challenging issues, more from a softer aspects than pure legal aspects. But in my view, a lot of this will get clarified as we see the new data protection and privacy law develop.
Sorry, didn't mean to interrupt. I thought so. Just quickly, I think to the point he made earlier, it's really how the organization makes the complainant feel about this, and how much trust can you establish. So if you can do that exactly like you did in this case, that's really important. That the person should feel that there is someone batting on his or her behalf. And I think then you should be fine, more or less, unless until there is clear out and out malintent, right?
So, okay, so moving on to the next one, and this time I mean it, it's a short answer question. Oh, sorry, go ahead.
Hi, I am Deepika. I am heading the HR function of an algorithmic trading firm. Which is where my question comes around data protection. So for us, intellectual property, data protection is one of the most important factors. So what I've seen in past, there have been cases in past, thankfully not with my firm, but in India as well as outside of India, where there have been code thefts. And like you guys also just said, no matter how much cybersecurity checks we put in place, there are always ways around it. In our industry, also because it's a bunch of IITians, the smartest people, tech grads available in India. So there have been cases where the person was found doing code theft. The firm took the legal course, confiscated all the assets of the employee. And at the same time, there have been cases where when the person was confronted, he admitted, and the firm did not really take a legal course of action. Instead, they did an internal investigation, confiscated the assets again. In such cases where the employee is cooperating, what would be the best case scenario? Is there a way that the firm can stop the employee from joining a competitive firm? If yes, does the Indian law permits that? If yes, for how long? Is there even a
Sorry, just before my panelists
Yeah.
go, is your question whether or not after an employee is guilty, can I stop him from joining
Yes.
a competitive firm?
Competing firm.
So the answer is no.
Okay.
I think from a non-compete perspective, I think the law is completely in a different realm than what that person has done. Yes, you can protect your data. Yes, you can protect confidentiality. Yes, you can enforce confidentiality if you find that that is getting breached. But at the moment, there is no overlap or overflow between what has happened in the past in your organization versus what he is joining. So there is no connection between these two. Yes, you can obviously go to court and take whatever preemptory orders, in declarations, injunctions, whatever from a perspective of not sharing that data, and whatever you can protect it. But there is absolutely nothing at the moment under law from a non-compete perspective.
So while we're on that, all of you must have been given those little bags with little booklets in it. In those bags, there's a booklet called Enforcement of Negative Covenants, right? It's one of the negative covenants obviously would be non-compete, and it discusses the entire legal system around enforcement of those aspects, and perhaps that question of yours can be answered. You'll find your answer within the four corners of that notebook. I think one of the things that you're probably trying to explore is, if the person has sensitive confidential information in his head, do I give him some sort of a cool-off period till the time that information becomes a little redundant? And that is something which is, I hope, captured in that paper somewhere.
Do you use gardening leave in India? Because in England you can have non-competes.
I think
Yes, as a
And that's the classic solution in England is to put somebody on, is to give is not to dismiss somebody summarily, but is to dismiss them on the full period of notice and give them gardening leave, send them home 6 months while
Vikram is waiting for his garden leave for last 20 years at NDA, but maybe he has the answer.
We've got case laws on garden leave, which basically says that garden leave can only be enforced during the notice period and not thereafter. So in this case law, and we are talking of the VFS case, it's the Bombay High Court, I think 2007 or something like that, which basically is, VFS tried to enforce garden leave after the term of employment, and the court disallowed that, saying that it can only be enforced during the term of employment, which is largely the notice period.
So we are nearing 7.
No, you all are done.
And so therefore we should possibly.
I think more questions over drinks. It's a better way to take free legal advice in any case, right?
So please join us in thanking the panel. Very interesting discussions.
On behalf of NASSCOM, I would like to thank all of you for being here. I would also like to thank our keynote speaker, Vidya Srinivasan, our panelists,